Afternoon. I'd like to call back to order the regular meeting of the Lane County Board of Commissioners for Tuesday, October 16, 2018 in our afternoon session. And I will note that Commissioner Farr is running late coming back from a lunchtime appointment. He's already called me and let me know he'll be about 10 minutes late, so he might miss a little bit of this item. So expect him to come running through the door anytime. So we have the first item this afternoon is item 14A from Public Works, which is the third reading and continued public hearing on ordinance number 1807 in the matter of amending Lane Code Chapter 13 to add, revise, and delete definitions and provisions to modernize and update the entire chapter, amending Lane Codes 10 and 16 to update references and definitions for consistency with Lane Code Chapter 13, and adopting a severability clause, file number 509 PA 1605453. And we have Lydia Kay here, but I think I'll start off first by saying this is a continued public hearing today from August 21st, 2018. Sorry, I almost forgot to read the required script. The purpose of Lane Code amendments the proposed Lane Code amendments are subject to the applicable criteria identified in Lane Code 12005, 12050, and 162522. The order of the proceedings for this hearing will be first the report by staff, followed by the public testimony, and then additional comments by staff. Failure to raise an issue with sufficient specificity today to enable a response may preclude appeal to the Land Use Board of Appeals on that issue. Prior to the conclusion of the public hearing, any participant may request that the record be left open to provide an opportunity to present additional written evidence or arguments regarding the application. However, the board is not obligated to leave the record open as this is not a quasi-judicial proceeding. It's a code change. At this time, I want to call for disclosure by any of the commissioners for abstentions due to conflicts of interest or biases. Commissioner Sorensen.
I'm relying on Mr. Clark's reference to me that I don't have any conflicts.
Commissioner Lyken.
None.
Commissioner Williams.
None.
And I have none, and I will check with Commissioner Farr when he arrives to make sure he has no conflicts. And I'll call for any challenges to the board's qualifications to hear this matter at this time. Seeing none, now I'll move to the staff report. And Lydia.
Thank you, Chair Bozovich. Good afternoon, Commissioners. Lydia Kay, Lane County Land Management Division Manager and Planning Director. And Amber is the real staff person who's been managing this project. But I just wanted to speak for a few minutes and just frame a couple of things for the board before Amber goes into her staff report. So as Commissioner Bozovich, Chair Bozovich mentioned, this is a continued public hearing. We were here before you on August 21st. At that public hearing, we had brought before you a draft that had changed between the Planning Commission and between the board. And so we talked about that. We talked about the changes that were made and why staff had thought that's what we should put before the Board of Commissioners at that time. And that's because a year had passed between the Planning Commission making a recommendation and us coming to you for a public hearing. That was deliberate because we were, you will recall, we brought Chapter 14 through in that time, and we needed 14 to be adopted first. So that was the draft that we brought before you back in August. There was a lot of public testimony regarding that. We heard that. We had some discussions with the board. And so one of the things that we had a lot of discussion about, and I expect that there will be some today, is with regards to legal lots. How do we treat legal lots? How do we define legal lots? At the public hearing in August, the board had directed staff essentially to look into different ways that we can define legal lots. And staff started doing that and ultimately realized that the simplest, cleanest way that we thought we could be moving forward is essentially to go back to what our current code says. It's very similar, the language that we've brought before you now, to current code, and it's very similar to the statute. So that's what we wanted to bring before you. That's what we think is the best proposal for us moving forward. That language, in our understanding, continues to allow an applicant to make an application for a legal lot and to present a number of different arguments, as has been done in the past. So that's one major thing, I think, and Amber will talk about the details. There was some testimony submitted late yesterday afternoon that raised the issue of the word contiguous. Do you want me to pause?
Yeah, if you don't mind pausing. Commissioner Farr, I just want to catch you up with that. We've gone through the explanation, the hearing, all that, and had an opportunity for board members to declare any conflicts of interest or biases. So I will ask you at this time, do you have any conflicts of interest or biases?
I have none.
Thank you. So that's on the record. Thank you. Okay, go ahead.
Okay, so actually, before I go into the definition of contiguous, after the hearing, staff went back to the Planning Commission just to talk with them about the changes that had been made. At that meeting, I said it was my error as the planning director, and it was not to keep the Planning Commission informed of the fact that we had made a change before we brought it to the board. So we wanted to explain that and also let the Planning Commission know what the current proposal was, and to have a discussion about that. Now, because there's this open public hearing, the Planning Commission wasn't deliberating, they weren't making a formal recommendation, and we let them know that, of course. But we indicated, and I think Amber has captured any comments that we heard that night, that was on September 5th, that we would bring those forward. So getting back to that question about contiguous. So this was some testimony submitted yesterday that raised a concern about staff having changed the definition of the word contiguous because in the testimony it indicates that that precludes an applicant from making an argument that roads divide property. Now, this question of whether roads do or don't divide lots has been very active. There's been a lot of conversation about it. And, you know, staff's position is, has been, and will continue to be that that question is a challenging legal question. Sometimes roads do divide property, and sometimes they don't. We've been looking at this. We've been working with legal counsel, of course, and so, again, this isn't something that we would recommend codifying. We understand that in some cases, and it's very complicated, some of the information that was submitted yesterday is very helpful in terms of looking at some additional case law. But I just wanted to be very clear about that, that staff's intent is not to surreptitiously change definitions of words in order to have a different outcome, that staff's intent is not to bring something forward today that precludes the ability of an applicant to submit for a legal lot being divided by a road, because again, that happens in some cases and doesn't happen in others. So I think those are the main points I wanted to mention, and I'll turn it over to Amber, and of course we can have some, if you have questions for me now, or we can address questions during the staff report.
Any questions for Lydia at this time? Go ahead, Amber.
So again, this is a third reading and continued public hearing of the revisions to Lane Code Chapter 13, and the hearing's been continued from August 21st. We received a number of comments at the August 21st public hearing, and we've received written comments at the hearing, and since that time, the written comments are attached to the board's packet as attachment 2 and attachment 3. Staff have thoroughly reviewed the comments, and in the memorandum to the board, we've responded to each of the comments that have been raised. And in response to the public comments, we've also made various revisions to the draft that is before you. That draft is provided in the packet as attachment 1, and that depicts staff's recommended revisions. After conducting the continued public hearing today, staff will recommend that the board close the public hearing, move to set a fourth reading and deliberations, and we'll recommend that the fourth reading be set for November 27th. And we'll also recommend that the board direct staff to revise the ordinance based on the revisions depicted in attachment 1 of the packet. Lydia mentioned the letter that has been submitted as of yesterday, and that's been distributed to the board, and there's also copies available at the back of the room for public review. And there was concerns raised with the definition of contiguous. I will describe the revisions that we're proposing to legal lot criteria, but do want to just mention that that criteria does not contain the word contiguous, so that does not appear to be applicable. To provide a summary of the staff report, staff have recommended some minor revisions based on recent appeals and case law. Mostly these are minor revisions. There's a couple that I'd like to specifically call out. So one is that staff have revised the draft to clarify that for a type 1 legal lot application, that is an administrative application without public notice that must be based on clear and objective standards. We're proposing to change the date for that application to only apply if a property was created prior to April 7th, 1949. That's the effective date of Ordinance 3. That was the earliest land division regulations that were adopted for Lane County. And so this revision's become apparent because in recent appeals, properties that were created between 1949 and the other land division regulations that were development regulations that were adopted in the county, there was still subdivision ordinance criteria that need to be addressed, and that evaluation of that criteria may not be clear and objective. For instance, in one recent LUBA appeal, that was a remand, LUBA directed the county to make findings whether a property was conveyed for agricultural purposes. That's one of the requirements for an exemption for a subdivision. And so that may not be clear and objective, but at best, that's more research than is typically associated with an administrative type 1 application. We've also added the provision at ORS 92017 that a discrete lot or parcel remains a discrete lot or parcel. And then, as I mentioned, there was a number of comments that was received at the August 21st public hearing, and then in written testimony that was submitted thereafter that's included in the board packet. And each comment's been fully addressed in the packet, but I'd like to cover 4 main issues that were raised. So the first is comments were submitted from the Midwest chapter of the Professional Land Surveyors of Oregon that described that the partition and subdivision requirements for creation of a drainage easement should be removed. And this is because those requirements are already addressed through Oregon drainage law, and they're also somewhat difficult to implement. For instance, when you're creating an easement, who is the party that's benefiting downstream? So it's somewhat difficult to fully implement that requirement, and the comments also assert that this provision hasn't been often required by the county. So it may be appropriate to further revise or delete that provision at this time, and if the board so directs, we can make revisions to the ordinance and return with at the 4th reading with a revised ordinance that deletes that provision or revises it. Comments were also received at the hearing that profiles should not be required for wetlands, that those are difficult to prepare. Staff concur and propose in the draft that's before you that just a wetland determination or delineation be provided for wetlands if that is available. And then the third issue, concerns were raised with the requirement that a registered land surveyor provide an illustration of each deed description and a legal lot verification. And as discussed with the board at the initial public hearing, staff have removed, in the current draft that's before you, removed the requirement for a registered surveyor to need to provide that drawing. Other professionals or persons may be able to prepare that drawing. Several comments were received citing concerns with the elimination of the legal lot criterion that previously provided other proof may qualify as creation of a lawfully established unit of land, and comments asserted for various reasons that that criterion should be added back into the draft. Initially, when we embarked on this project, the intent was to create a comprehensive list of scenarios that would create legal lots, because if that could be done, that would provide more certainty for both staff and applicants. However, all parties involved, staff, consultants, the Planning Commission have spent extensive work and time to try to create this list, and what has become apparent is that it's difficult to specify which scenarios invariably create a legal lot. Certain scenarios do not 100% of the time create a legal lot. In the last couple of years, we've received numerous appeals on various legal lot issues. We've received some reversals from the hearings official. It doesn't appear that ORS language includes a list that was consistent with what was previously proposed. And so at best, it seems at this point highly problematic to codify specific situations that create legal lots when those issues are frequently raised on appeal. So what we've done in the draft that is now before you is we're proposing revisions to the legal lot definitions and criteria that we believe more closely align with state law and the current code. So the revised criteria include only that a legal lot verification will be approved if the subject property is a lawfully established unit of land as defined by this chapter. And then we've also revised the definition of lawfully established unit of land and parcel to match those definitions in ORS Chapter 92. So the question is just, was the property created in a manner that was lawfully conforming to ORS Chapter 92, essentially? We believe that this approach is policy neutral, which achieves part of the intent of this project. It would not codify language that has yet to be resolved through appeals, and it's, again, more consistent with ORS Chapter 92, specifically the definitions in that chapter. And additionally, it does retain flexibility for applicants to bring individual applications forward where certain circumstances, like whether there's intervening state ownership of navigable streams, meandered lakes or tide waters, or public roads that may have created lawfully established use of land, could be considered on an application by application basis. So at this time, that concludes staff's report, or we're happy to answer any questions that you may have.
Any questions for staff before we move into testimony? I may come back with some after testimony. So if somebody wants to bring the folks that are signed up, and if folks failed to sign up, I'll make a call for additional testimony here. So don't panic if you didn't get your name on the list. So it looks like the first person is Ryan Carando, and followed by Jim Belknap. And if you guys kind of stay close to 3 minutes, I won't be absolutely firm with that, but we've got 6 people signed up, and this is the continuation of a previous public hearing. So go ahead, Ryan, if you want to step up and state your name and your address for the record.
Ladies and gentlemen, my name is Ryan Carando. I'm here representing the Carando family. I live at 35 Park Village Drive in Florence, Oregon, 97439. This is with regards to tax lot 200, map 17-10-34. We purchased that piece of property back in 1993, and my parents have held on to it for, 25 plus years. Recently, they're approaching retirement age, so I'm taking all of their assets under wing and getting them, I guess, prepped to go off onto that iceberg, I guess you could say. In doing so, they chose that they want to construct a house or sell the property. When we went to sell the property, our real estate agent told us that it may not be a legal lot, which was news to us. In a letter dated 15 January 93 from a gentleman by the name of Harvey Hoagland, associate planner, he stated that according to attachment 2, the deed description card for tax lot 200 shows that it was created in 1946 by the deed recorded in 1949, book 309, page 160, Lane County Deeds and Records. County survey records show that East Mapleton Road, County Road 1091, was dedicated in 1932. Land Division Regulations, Chapter 13, Lane Code became effective on 26 March 75. Legal lots are defined in Lane County Code 16-1 1.090 as, quote, lawfully created lots or parcels. Parcel is defined as, quote, a unit of land created by deed or land sales contract if there were no applicable planning, zoning, or partitioning ordinances or regulations in effect at the time. Definition of quote-unquote contiguous is intended to clarify the status of land divided by a public right-of-way. Tracts of land are the same ownership and which are intervened by a street, quote, local access, or public street, or county, state, or federal road shall not be considered contiguous. Therefore, tax lot 200 contains two separate legal lots. Later, we received a couple handouts showing that according to your records and or whatever literature, and I apologize for not being prepared. I came into this last week, and our attorneys, Watkinson, Laird, Rubenstein in Portland, and Laudman Laudnell down in Arizona, they're talking to each other to get all our appropriate documentation together. But as anyone knows, you get two groups of attorneys trying to get a bunch of CYA papers together. It takes some time. Our concern is that my parents are being required to pay fees to, and I guess this is just where we voice our concern with regards to definitions that are being revised or whatnot, now being requested to pay additional fees for what is already been deemed a legal lot that they were planning on putting a retirement home on. And now we're finding out that due to some typo or possibly revision of rules and regulations, they're being told that that is not the case. And I'm just letting you know that we are very concerned about that, and we'd love for you guys to get this squared away as much as possible. If there's any questions I can answer, or that, I'll go sit down.
All right. Thank you,
so
Ryan.
much.
So Jim, followed by Larry Thorpe. Thank you.
Thank
Thank you, Commissioners. My name is Jim Belknap, and my mailing address is P.O. Box 362, Cottage Grove, Oregon, 97424. Thank you for the opportunity to visit with you again today about the proposed changes to how we recognize legal lots in Lane County. I've appreciated being able to provide you with emails over the past month discussing some of these changes and attempting to put a human face on the impact of the proposals. I'm not sure I can put a better human face on it than the gentleman that just spoke. Before I start, I'd like to take a moment to thank the staff of the Land Management Division for their responsiveness to the testimony I gave last month that was also supported by the testimony of others and a substantial amount of written comments. It would be disingenuous if we did not recognize when we have been heard and listened to, and I appreciate the efforts the staff has made in response to what has been said. Now, that said, the elephant in the living room is the question of whether public roads divide land. My work for the past 40 years has been involved in rural lands. I've been a principal real estate broker for 37 of those 40 years, been involved in forest land management and logging, and since about 1992, been engaged in a consulting capacity for rural landowners in the land use arena. As I mentioned last month, I don't represent the major rural developers in our area. My clients, and this is a time-worn statement, but my clients are truly the mom-and-pop rural landowners. And as developed, often the heirs of those mom-and-pop owners. Much of my business is referred to me by attorneys, working to settle estates, or working with landowners who are going through the ends of their lives and the difficult process of preparing their estates. At every meeting, I begin by telling these folks, it's easier to divide money than it is to divide land. From there, we go forward, or sometimes not. A moment ago, I handed you a memorandum with a couple of attachments. In the interest of time, I won't make you suffer through my reading of that memorandum today, but I hope in your consideration of this matter, you'll find the time to read it. Some of my comments will be elaborated by folks here today who are more qualified than me to discuss the legal aspects of your decision, and I will leave you to consider their words. My request today is that you direct the Land Management Division staff to consider in their decision-making the historic interpretations made by the County Board of Commissioners with regards to whether a county road divides land. The county owes to the public a consistent and reliable response to an issue that has been acted on in good faith and settled policy for literally decades. This policy has recognized that roads, to include petition roads, divide land. Specifically, I ask that you leave unchanged the definition of contiguous in Chapter 13 as it is presently written. Included with the memorandum I handed you a few moments ago are two maps, and I have copies here with me. One is highlighted in yellow, good University of Oregon yellow. It's tax lot 200330, lot 100. Pardon me, lot, pardon me. I got ahead of myself here. This is one highlighted in yellow is 200305, tax lot 201. The other is in orange, and this is Oregon State orange for the fellow who owned it, a gentleman named Tom Lawler. The yellow lot, 201, is kind of where this all started. As discussed in my memorandum, this property was owned by Don, Wally, and Andy Sears, direct descendants of the original Sears family for which Sears Road and Bryson Sears Road are named. The three Sears brothers were seeking to settle the estate of their late parents in the sale of Lot 201. This case, in 1992, denying an appeal by no less than the Oregon Department of Land Conservation and Development, became the basis of the 2000 memorandum written by Jim Mann, a senior planner with the Land Management Division, which stated the question, do public roads divide land? The answer to that question was an unequivocal yes. The map highlighted in orange, tax lot 100, is owned by the estate of Tom and Helen Lawler. I represent the heirs to that estate who are wishing to sell an 8-acre parcel of land that is divided by Cottage Grove Lorraine Highway on its south boundary and Rudolph Road, a petition road, the primary focal point of the discussion before you today. And my clients are awaiting a resolution of this matter. At the conclusion of last month's Planning Commission meeting, I engaged the Land Management Director and her staff in a conversation and brought up Jim Mann's 2000 memorandum. A copy of that is also attached to what I just handed you. I was very surprised to find they had never seen it. I provided it to them the next day. The Mann memorandum and the resolution of the appeal of the Levenger case were the basis of the adoption of formal policy by the Lane County Board of Commissioners in 2005. That policy has categorically confirmed that public roads divide land, those held in fee title and petition roads. Nothing has come before this board to change that policy, yet for the past few months, the Land Management Division has directly defied that policy in issuing denials to requests for legal lot verification on parcels divided by public roads. No department, division, or other element of Lane County government has the authority to introduce their own policy in direct contradiction to previously adopted policy by the Board of Commissioners. I thank you for your time. I thank you for supporting the pledge that the changes to this code will remain policy neutral.
Thank you, Jim. Larry Thorpe, followed by Bill Close.
Good afternoon, Commissioners. My name is Larry Thorpe. My address is 36910 Edge Hill Road, Springfield. I sent you an email yesterday with a memorandum in which I discussed at considerable length what I think are the legal issues associated with roads being able to divide parcels and create legal lots, and the complications that are involved with it, and also what I think are the pitfalls if the county backs away from its long-established policy that public roads divide parcels and create legal lots. I'm not going to repeat any of that. You gentlemen can read it at your leisure if you're inclined. The only thing I would like to add, though, is in response to a comment by Lydia with respect to the use of the word contiguous and removing the language that was in the prior version, well, it's in the current version, and it's been in there for years, that parcels are not contiguous if they're divided by public roads. Very simple. Staff saying, well, you can still argue that if we take the language out. As I indicated to you in my memorandum, I spent 40 years as a lawyer dealing with these kinds of issues, and the first thing I would drag out if I were arguing that roads don't divide land is the fact that the county took that language out. Now, staff indicated that, gee, well, the word contiguous is not used in the definition of legal lots. But I assure you, it will come back to haunt you just as much as I assure you that you're going to be hearing from a lot of angry constituents who have been relying for years on legal lot determinations that are still appealable if you back off and say now, oh, gee, maybe they're not valid legal lots at all. If they get sued, you're going to hear about it. And I assure you that if you back off from the position the county has had for years, that will happen. I'd hate to see it happen. I think it's bad policy. I think it's bad for the people of Lane County. And I truly believe that if the full issue of whether roads under state law, public roads, can divide land and create legal lots, I believe the courts will say yes. I haven't seen anything anywhere written, nothing in the statute, nothing in the case law that indicates otherwise. I don't have anything further to say, but if you have any questions, I'd be happy to try and answer them.
Thanks, Larry. Bill, followed by Tom Lanphier.
Commissioners, Bill Coast, 375 West 4th Avenue, Suite 204 in Eugene. You have a letter from me, and it's kind of long and tedious, and I'm not going to hash through it. I always appreciate following behind Larry Thorpe. I've been doing it for 35 years. It's still a lot of fun. He summarized my issue very succinctly. I have handed out a single page from the current version of the code. Single point I would like to get home today.
Did you mean to get
Oh, that doesn't belong here. Oh, that actually was for a Eugene hearing. You can keep it. It's not. It's not in the record. These folks have the record material.
Okay.
Okay. For here, it's just entertainment, I guess. How did that happen? The definition. I've handed you out an excerpt from the current code. It includes the current definition of the word contiguous. There it is. There's nothing wrong with it. It's not broken, but the staff recommendation in front of you today proposes to change it. What are they going to change? They're going to take the entire second sentence and they're going to drop it out. Tracts of land under the same ownership in which are intervened by a street shall not be considered contiguous. That's been in there a long time. There's nothing wrong with it. Staff don't like it. Please, just leave it alone. This was Larry's suggestion to you. If you take it out, it's going to be used by people to argue that roads don't divide property. There is absolutely no reason why this sentence has to come out. The issue really comes down to, well, let me put it this way. My letter to you flags and documents in great and gory detail your 2005 code interpretation where you address this issue. And this is in the context of Levenger appeal. It came right up from the planning director through the hearings official, full Monty public hearing, and the Jim Mann 2000 exhaustive legislative history on the term contiguous was in the record. And this board said, we are sticking with our policy, roads divide property. And that is your latest, most definitive statement on the issue. Staff's really asking you to change that because what they're saying to you is, well, in some cases they might divide property, but in other cases they might not divide property. Staff's bone has to do with the petition roads, not the fee simple roads, but the petition roads. And there are hundreds of miles of, I'm guessing here, but it's a lot of miles of county roads which over the last century have been created through the petition process. So what's the petition process? We don't do this anymore, the petition process, but I just got three examples of three county roads that were created by petition process. There are a lot of them. And I just pulled the key documents out of the county road file and given them to you so you can look at them and see how the process for creating a road by petition works. Staff's of the notion that, well, maybe these petition roads are made out of a softer stuff than dedicated roads or fee simple roads which you buy. Maybe they're more like easements instead of like dedications or, fee simple deeds. And because of that, maybe if they're more like easements, maybe we're not so sure they divide property. Maybe they don't divide property. That's the issue. The point I'm making to you in my letter, and the point that Larry said more succinctly, is that there is absolutely, that's a great question to ask, but there's absolutely no state law that says petition roads don't divide property. The staff throw around a number of cases. I've addressed them briefly in my letter to you, but the point is none of them creates state law that you have to comply with. This is an issue that's still a matter for your policymaking. You made the policy in 2005. Let's leave it as it is until somebody says you have it wrong and it has to be changed. Now, who's this going to affect? People like the gentleman, the parents of the gentleman that spoke to you first. He's typical. There are hundreds and hundreds and hundreds of these people who, over the past decades, his was like 1992 or 1993, have gotten determinations from the county staff, one form or another, that they have 1, 2, or 3 legal lots based on the fact that there was a petition road cutting through their property. They count on it. They rely on it. What's happening now is people are starting to come back, as they always do, to get those decisions made formally with notice and an opportunity for a hearing, or to get a building permit or a special use permit based on those legal lots that were preliminarily determined decades ago. And the current staff, who now are nervous about petition roads, are saying, oh, you don't have a legal lot after all, because your property is divided by a petition road. And petition roads, they don't divide property. And now, is that consistent with the county code there, that second sentence? No, it's absolutely contrary to the current county code. Your staff is making decisions contrary to the county code. I'm sure they got a rationale for it. It's also contrary to your interpretation from 2005. This is the category of people that we're trying to take care of. So the easiest way to do it right now is to leave the definition of contiguous as it is in the current code. Thank you very much.
Thanks, Bill. Tom Lanphier, followed by Mike Evans.
Good afternoon, Commissioners. My name is Tom Lanphier. My address is P.O. Box 12257, Eugene, 97401. I support the changes that staff has made, abandoning the effort to define legal lots in a section of the code. When I was staff in the Planning Division in 2000, we tried to do the same thing and backed off because it was so complicated. The board tried it again in 2005 and again backed off because it was too complicated. So this is consistent with past board actions, backing off from that attempt. I support that completely. I also support keeping the definition of contiguous the way it is. Other people have explained why that's important. I can tell you that during my over 20 years working as staff down in the planning department, there were many times where I explained to people that roads divide land. That was the policy the whole time I worked here until 2008. So I can basically testify that that is true, what's being said. There are hundreds of people out there that have relied on that determination over the past, and they're going to have problems if you change it. There's one change being proposed to the definition of parcel. What's being proposed is adopting the definition right out of ORS 92. And that's a more limited definition than what we have in the code now. What's currently in the code matches the definition in Chapter 16 and ORS 215. If you leave it the way it is, it's more limiting definition. It doesn't include parcels created in compliance with applicable planning and zoning. It's just a narrow little definition of parcel as being a piece of land created by a partition. ORS 215 has a definition that incorporates the ORS 92 definition into it and adds on the additional language that is appropriate. And since the purpose statement of the Chapter 13 says we're going to have it in conformance with ORS 92 and 215, the appropriate definition should be out of 215. One example of a problem that creates, if you change it, the proposed code at 13.020 subsection 5, you've all heard this phrase most likely, a lot or parcel lawfully created remains a discrete lot or parcel. Well, if you change the definition of parcel to only be a partitioned parcel, then a parcel created by deed earlier than partition requirements won't remain a discrete lot or parcel. You have a definite contradiction there. So I'd recommend keeping the existing definition of parcel if we could, and I appreciate your time. Thank you very much.
Thank you. Mike Evans?
Thank you, Commissioners. My name is Mike Evans. I'm a land use consultant, address 475 Oakdale Avenue in Springfield, Oregon. I'm handing this out, and I won't bore you with going through it or reading it. Basically, it supports everything that you've heard previously regarding the, basically the legal lot issue and definition of contiguous. Just briefly, I agree with what Tom Lanphier just said about parcel. I hadn't noticed it before in any of the revisions, but they've eliminated some of the definition of parcel. And like he said, I think it's necessary that you maintain consistency between the Chapter 13 version and the Chapter 16 version. And as of yet, I think Chapter 16 still has the same language, has not been changed. So it used to be the same, it should remain the same. Bottom line is, like Tom said, I think the best, and I agree with staff, the best way to deal with the legal lot issue is to leave things as they are. Don't change the definition of contiguous, certainly. You, I think, understand at this point that the County Board of County Commissioners has an adopted policy concerning roads divide. If you eliminate the current definition of contiguous, then that policy becomes weaker and may not survive. One of the things you heard from Mr. Carando today, I'm glad he showed up. One of the issues is that people don't, although they got notice of some changes, they don't have any clue of what's about to happen to them if these changes were made. If there were, you'd get a lot more input from the citizens. In the spirit of Measure 56, I think, where the notice is given is people are supposed to get warnings so that they can come and defend them. I think this, in the county staff report, they indicated they'd send emails out to all the counties asking what their policy was on roads dividing. And they kind of indicated they got no response, or excuse me, that no county recognized roads dividing. And I don't think that's necessarily the case. From what I found out, different counties handle it different ways. And I think one of the reasons for a lack of response, I think there's only a couple of responses, and from that they concluded that no counties recognize roads dividing, was it's a very complicated issue, as you've heard today, and each county has a different way of dealing with it. So I wouldn't rely on that as a basis to consider eliminating that. Very quickly, Mr. Carando, Ryan Carando, who spoke to you first, I've never talked with him nor met him, and I've not met his folks, but I have talked with him on the phone. And let me give you the rest of that story. So they got a letter. It wasn't a preliminary land use decision, like many of them are, but it was an actual letter from the county saying that you've got 2 pieces of property. Actually, that letter wasn't given to them. It was given to the people that they bought the property from. So they purchased it on the basis of this letter saying you got 2 legal lots. So they sold one of the lots that had the house on it. Went into the county, and the county said that, initially said, well, you don't have a legal lot anymore. And that's when I got the phone call, and I said, well, you've got a preliminary legal lot, go in and apply for notification, get the thing notified, and let's see what happens with all this stuff going on. Now, if county roads don't divide, and this is a petition road, so if that doesn't divide, then what situation does that put Ryan's folks in? They sold a piece of property to somebody who, with a house on it, and if neither parcel is a legal lot, then what does that buyer have? What kind of liability then does Ryan's folks have? The neighbors aren't friendly. They try to keep people from buying the property across the road, so they're not friendly people. What kind of liability might be enforced on them because they sold a unlawfully created parcel? So just keep that in mind. That's the kind of thing that there's going to be a lot of out there if you don't maintain the course. Thank you very much.
Thanks, Mike. That was everyone I have signed up to testify. Was there anyone else that wished to testify on the Chapter 13 update? Seeing none, then I'll look to staff for additional comments.
Well, one initial comment to address Mr. Lanphier's comments regarding the definition of parcel and lawfully established unit of land. So the definitions, what we've tried to do with the revisions that are before you are to align the definitions more closely with ORS Chapter 92. There is a difference between the definition of parcel in ORS Chapter 215 because the use in that chapter is different. In ORS Chapter 92 and applicable to Chapter 13, a partition parcel refers to a parcel that's created through a partition. We've updated the lawfully established unit of land definition to include parcels that are created by deed or land sales contract, and those other scenarios that are, I believe, fairly consistent or mirrors the definition of parcel in ORS Chapter 215. So this seems to be more applicable to Lane Code Chapter 16. And I will also add that we went through the uses of the terms in the draft that's before you to make sure that those scenarios are being reflected in Chapter 13. I'll also address the term contiguous as used in the draft that's before you. So we did a word search for the use of that term. It's used in just a few places in the draft. So the few places that it occurs is the requirement for a control access strip, some requirements for sewerage facilities, and then also in the definition of tract. And if you do a search for the definition of tract, that also appears only in specific instances. So with regards to the assertion that it would kind of be part of the legal lot criteria, that word is not in the legal lot criteria that's proposed as part of the draft, nor is the term tract. And it doesn't appear to have that use, to have that weight in the legal lot criteria. The other thing that I'll mention regarding the term contiguous is that staff have not deleted that second sentence in the draft that's before you. That is something that was revised very early on in the Planning Commission proceedings. As far as we could tell, that piece about whether a tract is divided by a road was deleted at the first work session before the Planning Commission in 2016. And it appeared to be the case that there was a kind of an earlier iteration where staff had recommended a change to align that definition more closely with the Oregon administrative rules. There was some revision to go back to the definition of abutting, meaning parcels that are adjoined by at least 8 feet, but it appears that that was done very early on in the process.
And I'll just make a couple of comments. There's a lot of information that's being brought forward today, a lot of it which staff hasn't had a chance to review, so the letter and interpretation by Mr. Close actually wasn't received by staff, so we'll take a look at that information. Mr. Thorpe provided some information yesterday afternoon, so there's a lot of food for thought here that we are unable to respond to specifically. But I just wanted to note a couple of things. With regards to, it is correct, Mr. Evans stated that we sent out an email to the other planning directors, the AOCPDs, Association of Oregon Counties. We did hear back from a number of them. And from all of the people that we heard back from, they indicated that some roads, as we're saying, some roads divide land, but not all roads. And there's this kind of overly simplified response that if they're held in fee, they do. If they're petition roads, they don't. It's not that simple, but just so the board understands, that was feedback we received from a number of counties, including one planning director who was kind of couldn't believe that we had done it a different way. He said that's what he learned in planning school 25 years ago. So again, this is not something where the county is sort of out in left field, I think. So the final thing I'll mention, and I think the board will recall this, there are times where, and again, it's not staff's intent or legal counsel's intent to try and, create new policy. We're simply trying to apply the case law as we understand it. And so that's really the response. The same thing happened about a year and a half ago when we found that there was a case, Redco versus Polk County, that the county planning department had not been applying to properties with regards to whether or not there were ghost parcels underneath. And so we started applying that because we thought that was legally correct, and we have made that shift, which has been upheld at this point, I think, by LUBA. So that's all I'll say for the moment. We're available for questions.
So, questions for staff while we're still in the public hearing? Commissioner Lyken.
Thank you, Mr. Chair. And so this is regard to the part of the public testimony that we heard today. And the reason why this raises a red flag for me is, so we've heard testimony. I mean, a lot of folks in here, believe me, I've known for a long time, but the person I've known longer than anybody in this room is Mr. Larry Thorpe. And Larry and I go back long before I was in public office. So, and he's on the Planning Commission. So he has been sorting through a lot of this. And so you gave the definition of contiguous, but yet he's hitting contiguous. He's having heartburn on this. And I'm going to be honest with you. From my perspective, because of, while there's no doubt there's a friendship, personal relationship with Larry, but I've been on the other end when Larry's represented clients and gotten beaten up, so that's fair game. But on his testimony and what he has in the written record as well, so he brings forth the issue of contiguous, and the part that I think kind of has me a little bit more, so Amber, you're going through, you're talking about contiguous, where it states, and he says, furthermore, the definition of contiguous without the language stating the parcels intersected by a public road were not contiguous was reviewed and recommended for approval by the LCPC. Has something changed? Because frankly, what we're hearing here is a very consistent testimony from folks on this very issue. And I'm bringing forth Larry because he's on the Planning Commission. And by the way, on the email, the chair of the Planning Commission basically gave a boy howdy to Larry and on an email back to the board suggesting that you've hit it. This is correct. So there's something going on here, and all I'm looking for is just maybe a little bit of just from a feedback from staff on has something changed here. why the consistent message, but in particular, now granted, what Larry stated is that he is here today speaking on his own and not representing the Planning Commission. I think that's important to note as well. So he is speaking for himself, but at the same time, as a member of the Planning Commission who has a history and a strong understanding of land use in the state of Oregon, just help me out on this one. So, because right now my flag has raised and it's getting red, and so I just help me out on this to kind of explain where we're missing it, because we must be missing something as far as this language is concerned.
Thank you, Commissioner Lykin, Chair Bozovich, Commissioners. The comment that Amber made in the staff report is correct, that in that we brought the the Planning Commission, a number of changes that were ultimately recommended for approval, and it included that definition. Frankly, this whole issue of contiguous has sort of surprised me. As I mentioned, we went to the Planning Commission on September 25th. This wasn't discussed then. So this is something that we're still trying to catch up on a little bit. So I don't know what more to say on it besides that this wasn't something the Planning Commission asked us to bring to the board. I will say I had a phone conversation with the chair of the Planning Commission, and his conversation with me was that he was not endorsing that statement by Commissioner Thorpe, and that we had an additional conversation about some things that we'll do tonight because we do have a Planning Commission meeting. I just wanted that to be clear. That's
I appreciate that, but there's an
have.
email that's basically suggesting another view, and so but I'm fine with that. I don't have an issue with that. It's just the challenge right now is we've got this coming from a member of the Planning Commission, and I'm going to tell you right now, all the years I've known Larry, he's never been bashful in his entire life. I can tell you that right now. And I've got my butt chewed by him before, and it's, and that's just life. But when you represent the public, but so that's why I hope you understand why the flag has been risen a little bit here, and that's why I think we need to figure this. Where's this coming from? And why the consistent message that we're hearing from the folks who've testified on, because contiguous seems to be the word of the day. And so I think you need to kind of, again, help us out with that. I appreciate that. Thank you, Mr. Chair.
Before Kier responds,
Yeah.
I want to jump in a minute because I do think folks aren't understanding why the flag's been raised and aren't understanding what Mr. Thorpe was getting at. At the time this first came to the Planning Commission, and the change in the definition of contiguous was at the same time we added all the language that clarified when a legal lot could be created. Then you came back to the Planning Commission and told them you were going to go back to the old version of what basically the old legal lot language and not trying to define legal lots. Their presumption at that time was that also meant you were going back to the old definition of contiguous. And it wasn't until after that meeting they found out you had left the definition of contiguous changed, which was being changed at the same time of defining the fact that roads could divide land. And then you took that roads could divide land out of the legal lot section, but didn't bring the roads dividing land back into the contiguous definition. That's why it's under discussion. Does that make sense? That's the, from the Planning Commission's perspective, at least, or from Mr. Thorpe's perspective, that's what they're seeing. That it didn't get discussed that night at the Planning Commission because they thought when you said the language was reverting, that also meant the definition of contiguous.
Thank you for that clarification, Chair Bozovich. For the record, my name is Kier Miller. I'm the planning supervisor, and I appreciate that you brought that up because that is becoming clear to us. As Lydia mentioned, just last night when we saw Mr. Thorpe's letter, that's the first time we had heard of this term, and that term was, or not heard of the term, but of the issues with it. That language was changed back in 2016 when we started this process. It's been a couple of years and there was different staff working on it. So it did catch us a little off guard. When we indicated that to the Planning Commission that we were going to revert to the original language around legal lots. That term itself, as Amber mentioned, isn't anywhere to be found in the criteria related to legal lots. I understand that it can be used as a potential argument to justify that roads divide land. So I can certainly understand why there's desire to keep that language in there, but it wasn't an intent of staff to maliciously remove that language. It was something that had been done 2 years ago and hadn't been inserted back in. So I just want to say thanks for clarifying that, and I think that's the issue we find ourselves in today.
Yeah, and that's kind of the sensitivity to that statement in the staff report that LPC, the Planning Commission had actually seen it and didn't have comment on the change.
Right. I would like to just caution that staff through legal counsel, we have reviewed a number of these road divide land issues, and we find that in every case, it's not as simple as a road divides land. There are issues where roads do not divide land. According to your own county council staff, our analysis with other planning directors across the state. So having that definition of contiguous, while is certainly in line with past practice for the last 35 years, it may not in every case be accurate. So I just want to caution that as well.
Any other questions for staff while we're still in the public hearing? So
Actually, I do. I'm still trying
to formulate.
Yes, I am. But and I'm looking at the 13010 definitions. It has contiguous, having at least one common boundary line greater than 8 feet in length, and that's where the sentence was eliminated, was deleted, which says, let's see. Tracts of land under the same ownership which are intervened by a street shall not be considered contiguous. Have people made personal land decisions based upon this definition right here in the past? Is that one thing that we're trying to address right now?
Commissioner Farr, Chair Bozovich, I can't speak to that. I mean, certainly as Mr. Miller said, I think that language in the definition supports the idea that roads divide land in all cases, but the criteria by which we review whether a lot is a legal lot or not never touches this definition of contiguous. So if the
Why
question...
do we have the definition here?
Well, because it's used in other, it's used in other cases with regards to, as Amber mentioned, there's other situations that the word contiguous is relevant in the code. So it's...
So these definitions, I'm trying to look at this from a layperson's point of view here.
Sure.
I don't have land to sell, I don't have land to buy, and I don't sit in your seat. But if I look at this set of definitions, I cannot use this set of definitions as an accurate set of definitions unless I know how it applies to the particular documents that I'm looking at. So this set of definitions is really worth nothing.
That's not accurate, no. And
Okay, good.
That's not what
Good.
Ms. Kay is saying.
Explain that.
Part of the issue, the issue we've been discussing is broadly whether or not roads, however you define roads, divide property and create separate legal lots because the road bisects a chunk of land, okay?
I understand
This
what you're saying.
definition of contiguous could be used as an argument as to why roads divide land, but it's not conclusive. It's not the same thing as saying roads divide land, because you're dealing here with contiguous issue which applies in situations other than legal lot determinations. It's not part of the terminology used in legal lot determination section. It goes to other things, and that's why it's supporting argument, but it's not conclusive as to the issue of whether or not roads divide property.
So what does this set of definitions apply to then? What could I use this as my definition? Where could I use this as my definition? I'm trying to understand why this definition doesn't apply to the other documents.
So in the draft that's before you, again, there's just a few instances where you see the term contiguous, and it's in the control access strip requirements, some of the requirements for individual sewerage facilities, and then also the definition of track, which also has limited uses. So there are instances of that term that are in the current draft and the adopted draft, but it doesn't appear in the definition of lawfully established unit of land, which is the definition, how how state law looks at how a parcel can be created lawfully.
I think in general, the issue of whether or not something is contiguous has some important effect in other situations, not necessarily relevant to establishing legal lot or legal unit of land.
So my error then is considering this set of definitions, actual definitions then, is not definitions.
It is a definition, yes. They are definitions relevant to the code.
Maybe I can help clarify a little bit. Commissioner Farr, when we're interpreting and administering the code, the definitions, if we have a question about how a term is used, we go and we look up that definition in the code and we say, this is how it's intended to be used. In the legal lot section, what we're talking about, that term contiguous isn't used. So it isn't invoked in our interpretation of the legal lot provisions. It's used in other sections of the code, and it's in the code, so I can certainly understand the confusion, but it's not part of the criteria for legal lots. It makes sense and is in use in those other parts of the code that Amber mentioned, control strips, tracts of land. We use that term contiguous, and if there was question about what it meant, that's when we would go to the definitions and look it up.
Good job. Thank you.
Thank you.
Okay, so if there's no one else that has comments, then I've got a couple questions and all. So I understand where contiguous is used in the code. My issue with removing that sentence out of there is I cannot think of a case where a road is not separating a parcel as far as the definition, as far as contiguous goes. When you're talking about a control strip, you wouldn't place a control strip across a public roadway. Or it wouldn't involve a piece of land that's across a public roadway, because you're talking about a control strip that's accessed from the public roadway. So it doesn't really apply in the case of control strips. When you talk about sewer and contiguous parcels, you wouldn't run a off-site sewer line through a public right-of-way necessarily without getting facilities permits and everything else. But, in either of those cases, the road makes that a non-contiguous parcel. So I don't understand the harm in leaving that language in. That it's still not contiguous because the road separates it. Because contiguous means 8 feet of a abutting property line. If there's a public road between two pieces of land, where's the 8 foot of abutting property line? So it's just a continuation of that definition of contiguous. So I don't see an issue with putting the language back in, and it prevents the use of that language as a tool for appeal in the future. I know it doesn't apply to legal lots, but as a former registered professional engineer in this state and another state, having supervised registered professional land surveyors under my direct supervision, I can't think of when a public road does not that does not break contiguous. I just can't think of a case. So for me, just getting back to the practicalities of it, why take the language out? Even if it's a partition road, if it's being used by the public, there's no continuity between those two parcels. They're not abutting. They don't touch. And in fact, we've gone to the point where you have to have 8 feet of contiguous property line to be considered contiguous. You can't have corners touch, which they used to do in the old days sometimes to try and get around some of the rules, So for me, I would recommend put the language back in. Plain and simple, and we'll prevent the argument that we took it out because we were recognizing that, yes, I agree with you, not all roads create a legal lot. There's cases when they don't. And that's legal. That's one of the reasons why we decided to try not to define what creates a legal lot and go back to the old language. But we don't need to feed the fire by then changing our definition of contiguous when it's unnecessary to change it. If there was a good reason why, if you can come up with a clear legal example of two parcels remaining contiguous with a public road dividing them, I'll buy into it. But I can't think of a clear legal way that gets you 8 feet of abutting property line.
Chair Bozovich, Commissioners, certainly we can leave it in if that's the direction of the board. And again, as Amber mentioned, there's some other things. We are coming back. We're recommending coming back on November 27th for the fourth reading. So if the board directs us to do that today, absolutely, we'll just strike that. I mean, we'll add that back into the definition.
Before we leave contiguous, Commissioner Lycan has a.
Yeah, so what,
other to go to.
and I know Commissioner, or Chair Bozovich had another question that he wanted to ask you too, but I just wanted to say I strongly support this. And here's the reason why, because Keir talked about interpretation. So if we're talking about staff today and you're interpreting, my guess is you can work with the folks who are coming in here and especially on a project that's moving forward. But 10 years from now, if Lane County decides to hire a planner out of Cal Berkeley, how do we know that what interpretation is going to be based on something that's maybe not in writing? And that's, so I just want to say that I endorse this. I'm going to be a head nod definitely in supporting this piece of it by making sure that language, it has to be, I think, right now. And I think it, in the foreseeable future, just my thought. So, thank you. Thanks, Mr. Chair.
Thank you. So I want to go back to definition of parcel because I'm not sure I completely followed the back and forth between ORS Chapter 92 and ORS Chapter 215 and how leaving out the other ways parcels were created in the past, we're still covered because I'm concerned about that as I live on a parcel of land that was created by deed after 1949. So I'm a little concerned that I'm suddenly not living on a legal parcel. So I want to just clarify that whole issue around ORS 215 because ORS 92 is the chapter specifically around subdivisions and plats, and 215 is a little bit different section. So I want to understand that.
That's correct. So as Amber mentioned, what part of our intent, part of the direction was the board was to make the code align more closely with state law. We have this unique term in Lane County, it's called a legal lot. Other counties don't really use that term. It's in statute, it's called a lawfully established unit of land. We've met with the state surveying group, and they've sort of endorsed that the county move away from that term legal lot and use this term lawfully established unit of land. In ORS 92, it defines what we used to call legal lots in a couple of ways. First of all, it's a lot created through a subdivision process, or it's a parcel created through a partition. That's the way it's defined. But then there's a separate definition in there which speaks to a lawfully established unit of land. And that's a unit of land created through, a deed or land sales contract at the time there was zoning, or previous to that if there was no zoning in effect. So what staff has done is they've inserted that definition of a lawfully established unit of land into the code, which is the catch-all for those things that aren't lots or subdivisions, which what Mr. Lanphier brought up, I think, is some sort of a technicality in the code language that there's a provision in ORS 92 that says that lawfully established, or a lot or parcel shall remain a discrete lot or parcel. So that language, as it's presented in ORS 92, doesn't appear to invoke this term that a lawfully established unit of land is, shall remain a discrete lawfully established unit of land. I think that gets back to the platting requirements where, to get rid of a plat, you need to vacate it, or you need to somehow make it clear that it's no longer in existence. And I think that language is there to sort of solidify that theme. I don't know that there's any real concern. Frankly, it makes me a little uncomfortable that we define under our definition of parcel those things which are defined under statute as a lawfully established unit of land. So that was the intent in clarifying that.
Yeah. I'm comfortable as long as we keep some version of that lawfully established unit of land. That's really the important piece. So as long as we can make sure that we haven't left that out accidentally, I'm clear that basically covers everything else besides what's created by subdivision or partition.
That's correct.
Which brings me to my final question. And this is kind of a bugaboo I've gone around with some of you all about before. I want to understand that what we're doing under 13070 does not apply to a partition of 3 parcels or less. Because it talks about subdivisions and serial partitions, but I'm not quite seeing a criteria for just a simple partition of land, which is not a development activity.
So there are separate criteria for partitions of 3 or fewer parcels, and that's at 13060.
Okay, I just wanted to make sure, because it was a little confusing to me, the term serial partition. And I wanted to make sure we weren't requiring of anyone that was doing a partition to do things like wetland delineations or, providing contour maps or anything, because when you're creating a parcel under a simple partition of 3 lots or less, you're just creating a legally established unit of land, not necessarily a buildable unit of land. Therefore, and it's not a development activity, it's a legal activity that you shouldn't be able to exact anything from the property owner relative to requiring things like wetlands delineations or anything that matters about buildability, because you're not developing the land. And I want to just make sure that's really clear, that we have those separate, 4 lots or 4 parcels or more. Yeah, that's development activity under the definitions and under court cases of the past. But when we're just doing a simple 3-lot partition, I don't want to, have us trying to require things we would require of trying to prove out buildability, because that's really not part of that. So as long as we're clear, I'm good with that. But I was a little bit confused by the term serial partition.
Thank you, Chair, for pointing that out. That language comes out of ORS Chapter 92, and I believe what it applies to is where there are 3 parcels created, and then the owner has another contiguously owned property that they divide, and so they're effectively creating a subdivision through consecutive partitions.
Or they're partitioning a previously partitioned parcel.
I believe what that applies to, but the partition, the traditional partition of 3 or fewer parcels, there are separate criteria that are proposed for that scenario.
Just want to make sure that was really clear, because that's been an issue, because there is case law around partition parcels versus subdivision.
And both the Planning Commission and the board made that very clear. And so when we were starting this, we sort of took out some of the language that was in the code that had requirements for proving things up at a partition that we no longer will have with the adoption of this code.
Good. Thank you. I just want to make sure that was clear. So I think that gets through my questions relative to the lawfully created units of land and contiguous and partitions. So that was all my questions. Any other further questions from the board? Any other comments from staff before I close the public hearing? Are we allowed to take any further? I'm looking at Andy. I've got somebody raising their hand wanting to provide additional testimony, so.
Hearing is still open, so it's at the
Hearing's still
discretion
open.
of the chair.
At the pleasure of the board, I think I'll let Mr. Evans have a second shot, because I think he's replying to some of what's been previously said.
The argument, I just wanted to have permission to submit by email Mr. Carando's legal lot verification. I think it leads to, or will show you the unity of the necessity of the contiguous language. So I'd just like to email that to you after the record closes. Good?
Well, yeah, the board hasn't dealt with the record as of yet.
Yeah, I think we might be able to leave the record open for 48 hours or something to make sure you can get that in. Bill, did you have one other item?
I have the last word. Thank you very much. I sent you a absolutely stunning letter yesterday with 4 attachments. I think it must have been too big because Lydia was kind enough to say, hey, kid, we never got it. So I probably should have looked at the megabytes before I shipped it. But at any rate, so by hook or it's in the record. We'll get it to you. In way of a final editorial comment, I appreciate the fact that the second sentence of contiguous is going back in. I think we all understand that now. But I also appreciate what I heard from the staff, which is, be that as it may, we're not promising to treat land divided by petition roads, mere petition roads, as creating separate legal lots. That's what I heard. That's a problem. And we have a lot of clients who have beginning denials based on that policy, which is a staff policy. And that's the issue which is really crushing people right now that we have to get resolved. I would like to think it was resolved by your 2005 interpretation, which is discussed in my letter, but maybe not.
Yeah, I would think if we're going back to the original language, the 2005 interpretation still stands.
Yeah,
Well,
but, go ahead. Yes.
let me weigh in, because I'll repeat what I said earlier, and I thought about doing this as well, that the words in the definition of contiguous, at least in my mind, are not synonymous with saying all roads divide property into legal lots. And I agree with Mr. Close that that's an open issue. I have some disagreement with Bill about the effect of the board's 2005 interpretation, because what you're talking about is what's the meaning of state law? We can have a general policy about how we think the law is interpreted and how it's applied, but ultimately it's I think a definition for state law, not a county code matter.
But yeah, it's where we start from versus where somebody might be able to appeal us to.
Correct.
So, and I think our 2005 policy is where we start from.
Yeah.
And if somebody chooses to appeal us and try and get a better definition of state law out of the courts and LUBA or the courts, that's up to them.
Yeah, and I'm sorry, I'm not suggesting that the staff is not going to follow or that interpretation is irrelevant. I just want to point out that what we're dealing with, I think, are questions ultimately of state law, not county code interpretations.
Yeah, which most land use is after Senate Bill 100. So it's all interpretations of state law. But it's how we apply it locally, and what's our first crack at that interpretation or our policy of how we wish to interpret it locally until we're overturned by a higher authority. So with that, I would, this isn't a quasi-judicial, so we don't need to have a motion to close the public hearing. We just, but then I wanted, before we do though, I imagine in the final motion though, for the approval of the reading, we'll need to discuss, that we've closed the hearing in that motion, but also if we're going to leave the record open for a short period of time for these couple of emails to be received. I think we've had the record open a long time on this, so I don't want to have it be an interminable period. So is 48 hours or 2 days till 4 o'clock on Thursday enough time for you guys to get the supplementary information? So if we're going to, so I would propose that we close the public hearing today and hold the record open for additional written materials till 4 o'clock on Thursday, and then set the fourth reading and deliberations for November 27th.
Correct. And also, if the board could give staff direction, if I've heard pretty clearly that we're going to add back the language in contiguous, so we'll add that language back in. The other changes that staff have proposed, do you want us to make those part of the final draft, including removing the drainage language that Amber brought up?
I think as Amber walked us through the written comments and replies to the written comments, I didn't hear anyone that objected to those. Is there any objections to those changes that were proposed by Amber to address the written comments? Things like the drainage issue and the profiles of a wetland, et cetera. So I didn't see anything there. I know that there were at least 2 clear affirmations of putting the language back into the contiguous definition. I haven't seen a third, so I'm looking for a head nod for the third. There's 2 right there. And I think we heard, the discussion about the lawfully created unit of land, so I don't think we need further there. So I think that's the only real change is that by the board is asking for the 27th is that bringing back that sentence into the definition of contiguous.
And sorry to clarify, the drainage easement language is not removed requirements are not removed in attachment 1 in that draft before you. But with the board's direction, we can go ahead and add the language back into the contiguous definition, remove the drainage easement requirements, and then make all the changes in attachment 1 that are depicted.
Right. Okay, excellent. Thank you for that clarification. So with that, do I have a motion? Commissioner Lykin.
Thank you, Mr. Chair. So at this point in time, I'd like to move the third reading and set the fourth reading on ordinance ordinance 18 for November 20, what is it? Oh, excuse me, 1807, thank you. Ordinance 1807, leaving the written record open till 4 PM on Thursday.
Closing the public hearing.
And closing the public hearing, thank you. And closing the public hearing and set the fourth reading for November 27th, 2018. Do you need a time certain? All right, so we'll leave it at that.
Is there a second?
Second.
So it's been moved by Commissioner Lykin, seconded by Commissioner Williams to close the public hearing, keep the written record open until Thursday at 4 PM, approve the third reading and setting the fourth reading for November 27th for ordinance number 1807. Any discussion to the motion?
Mr. Chair.
Commissioner Lykin.
I just wanted to say thank you for the testimony, but I also want to say thank you to staff. You're being patient on this, but I think it's very important. We need to be. But I want to say to staff, thank you for treading through this. And while we hear testimony, but I think part of it is some of our own experiences as well. But also, just a big compliment to you. You're working on this, and you're listening to our direction, but also listening to the testimony, I think, on some of these important issues. So I want to say thank you to you and the work that you're doing as well.
It's been a lot of work.
Yeah.
This whole code update.
Yep.
I'll repeat that. Thank you. Any further discussion to the motion? All those in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously. Thank you.
Thank you very much.
And that brings us down to our next item, which is, if I can get my papers rearranged here. So I got handed too many pieces of paper in that last one. Item 15A, which is Order 1810-1609 in the matter of approving the urban renewal plan for the city of Cresswell. And we have Sarah Means, our Community Economic Development Manager. And guests.
And guests.
And some paper on these things.
Thank you.
Think how bad it would be if there wasn't that paper reduction.
Thanks for your patience while we get set up
Okay.
here.
The room's still clearing anyway.
Oh. Yeah. I don't know how we make it go up on the cable. What's that? We make this go up.
Thank you for your patience in waiting out that
Diana?
long code issue.
Interesting.
It was very interesting. Thank you.
Just try pushing some buttons. That's what we usually do.
Diana, Steve is pushing buttons. If you can hear me.
Warning, warning.
Steve is finger poking.
Me. Yeah, right?
You have
Hopefully.
15 seconds.
I don't know, and I am not the person, I don't even deal with that thing.
Steve, you getting instructions from above?
Oh, he's coming down. Oh, there it is.
Oh, we got it.
Woo. Well done.
From the man upstairs, in a manner of speaking.
Thank you.
That was pure luck. That was good.
Okay, apologize for that technical challenge. Good afternoon. Thank you for hearing this matter today. I'll let my guests introduce themselves, and as we move forward, actually, let's go ahead and do that now.
I'm Michelle Amberg. I'm the city manager for Cresswell.
I'm Michael Hart, Economic Development Coordinator for the City of Cresswell.
I'm Scott Vandenbos. I'm the Urban Renewal Consultant for the City of Cresswell from Elaine Howard Consulting.
So, and we also have Mike Halls in the audience, our assessor, given that this is an urban renewal topic and I don't do taxes, he does. And so I wanted to make sure that any questions you might have that are tax related, he might be able to answer. So we're here today. We don't see a lot of urban renewal plan approvals at the board level. And so this is a little bit new. You're all very familiar with other things like enterprise zone and that sort of thing. This is a little bit different than that, and so I wanted to make sure that we had plenty of resources for you with any questions that you might have. The board, at least in the 9 years that I have been here, has not approved an urban renewal plan, to my knowledge, and so this is a little bit different. You're being asked to approve this plan because there is about 0.9 acres of property proposed to be included in this district, but is currently outside of the city limits. Now, it's within the urban growth boundary outside of the city limits. So by statute, the Board of Commissioners are required to approve this plan. So this is why you're seeing this today. There's a lot of information that you're going to get today. You've got subject matter experts here. I wanted the representatives from the city of Cresswell to give you a brief overview of what they're proposing to do as part of the urban renewal plan. I think you'll find it's all very critical, necessary infrastructure-related type projects, but I want them to have the opportunity to express that. And then Scott's going to give us Urban Renewal 101 and dive a little bit deeper so that we can make sure that we're all very well aware of what we're looking at here and what we're being asked to approve. So at this point, I'm going to turn it over to Michael and Michelle to talk a little bit about the specifics of their plan.
Thank you. So I'm sure you guys have been to Cresswell a few times and noticed that over the past 20 years, it's looked pretty much the same most times you've been back. Bald Knob is still empty. All the northern industrial land is still empty. Reinvestment has been slow. And the big reason behind that all is our lack of water, wastewater, and street infrastructure. We have modern plans, modern planning. We don't have modern infrastructure. We've identified the cost of that infrastructure. We've talked to developers. I think since I've been working there for about 2.5, close to 3 years, I've spoken with about 4 or 5 developers who have approached us, had a lot of ambition, heard the price tag of what we have to make in the ground, water and wastewater pipes, and then left. And then that's the last we hear. So we got fed up, and we're proposing a new funding mechanism, tax increment finance, that's made available through the establishment of an urban renewal agency and a boundary and urban renewal district. So yeah, broadly speaking, we plan on updating Highway 99, putting new pipes in the ground going north and south, and fixing the jog as you drive through Cresswell. I don't know if you're familiar with it. You have to take a right and then a left, and it's a very bizarre traffic pattern. So without any further
somewhere
ado,
involved in that.
yeah, it's a pretty bizarre situation at that intersection. And it's surprisingly quite constraining to our industrial lands we have just to the south at the Bald Knob site. Standard tractor trailer can't fit through that intersection without taking extra lanes or a pole. So yeah, with that said, I'd like to leave you with Scott's presentation. It should be very informative. You have the opportunity to ask me questions if you'd like about any of the projects we're proposing.
Okay, so before I get started with the presentation, I wanted to just briefly go over the role of Lane County today. And that is 1, to review the Cresswell Urban Renewal Plan, and 2, to actually vote on the Cresswell Urban Renewal Plan as their unincorporated properties inside the boundary. And this is a not so normal thing to do, but it needs to be done. I always like to give a roadmap at the beginning of my presentations. This one is a rather long roadmap, as you can see. The first thing is the Urban Renewal 101, and then we'll get into specific Cresswell urban renewal items, the boundary, the state limitations and how they conform to the state limitations, the maximum indebtedness, the proposed projects, what the impacts are to Lane County, and the next steps. So why use urban renewal in the first place? And I've given this presentation, hundreds of times, and I've boiled it down to the fact that urban renewal can make things happen that simply wouldn't have happened before. And that's really what we're trying to do in Cresswell, is they've got industrial land that needs to develop, and it's just not going to develop unless it's shovel-ready. And urban renewal is the funding mechanism that can make that happen. And then we will see that development, and everyone will benefit. This is our Urban Renewal 101 animation that I had my design guy make. We all know how property taxes work. If you own property, you pay property taxes to regular property taxing jurisdictions like the city, the county, the school district. And as most informed citizens know, and a surprising number don't know, property taxes, the amount you pay for property taxes increases every year. And it's because the assessed value of your property increases by around 3% each year. And usually those increases in property tax revenues go to the regular taxing jurisdictions. But urban renewal is the establishment of a specific geographical area that is smaller than city, inside the city. And what happens with an urban renewal area is the increases in property taxes for that area, the value that is represented by that, instead of going to the regular taxing jurisdictions, now goes to the Urban Renewal Agency. That is in a nutshell how urban renewal works, and of course I will go into much more detail, but I like to give the high-level overview first, and then we'll talk about why we're using this specifically for Cresswell, and it is to improve the sewer infrastructure, improve the water infrastructure, and improve the transportation system to allow for new development to occur. That is, and this is a great urban renewal area, and it's one that I use as an example of the right usage of urban renewal all across the state. So now I'm going to get into my 201 urban renewal, and we're going to talk now about what is urban renewal, what's blight, how does it function, how does tax increment finance work, what the state limitations are, and how a plan is adopted. So urban renewal is unique amongst economic development tools because a lot of the times you'll see that there's a city plan that's adopted and it's not funded because there is no funding source for it. And we see that all across the state where urban renewal is used as the financing mechanism for an already adopted master plan of some sort. And then there's the tax abatement economic development incentives that are funding but not specific to any projects of a master plan. Urban renewal is like a master plan with its own funding source, in that these projects are going to happen eventually. It may take a little bit of time because urban renewal is rather slow to develop, but they will happen. And it does function, as I said earlier, on that increase in tax revenue. This is a map of all of the urban renewal areas in the state of Oregon, and at last count there were over 100 active urban renewal agencies. It's used everywhere, big cities, small cities, from Cresswell to Portland. So now we're going to get into what cities really hate having associated with their city, which is blight. No city wants to hear that they have a blighted area, but in order to qualify for urban renewal, you need to have blight in your urban renewal area. And it is a specific legal definition. It covers underdevelopment or underutilization of property, poor conditions of buildings, and inadequacy of infrastructure, including streets and utilities. And Cresswell definitely qualifies under ORS 457 as a blighted urban renewal area. Once an urban renewal area is established, it becomes really its own entity with the urban renewal agency, in that it has an income source, it has expenses, and it has a spending limit. The income source is the yearly TIF or tax increment finance collections or property tax collections. The expenses are whatever the urban renewal area spends on projects, programs, and administration that year, and the spending limit is what is called maximum indebtedness. And that's the maximum amount of money that can be spent on projects, programs, or administration over the life of the area. And that is the constraining factor on an urban renewal area. In the projections for this particular urban renewal area, we give you a duration that we estimate the urban renewal area will last. If economic conditions are better, the area would close earlier because it would reach its maximum indebtedness earlier. If economic conditions decline, the area could go longer because it still has to reach its maximum indebtedness. The duration in these is no longer the constraining factor of an urban renewal area. How does urban renewal financing work? This is an illustration of the two different revenue streams that happen once you form an urban renewal area. There's the frozen base revenue stream, which is representative of the taxable assessed values of the properties inside the urban renewal area the first year it was formed. And any property tax revenue from that assessed value still goes to the regular taxing jurisdictions as normal. Any increases above that will now go to the urban renewal agency. And if there were yearly tick marks, you don't really see substantial urban renewal revenues in typical urban renewal areas until year 5, year 10. And that's when projects start getting done. Urban renewal is a long-term investment. But urban renewal can also be used, and we don't show it here, but we used to have a graphic that shows that it can be used as a debt instrument. You can be used to secure a loan or a bond, and you can use your income on an annual basis, just like you would use it to secure a mortgage. I had a city councilor, an ex-city councilor, talk to me and say, well, couldn't you do the same thing as urban renewal by just putting away 3% of your property tax collections for the city putting away that much money? I said, well, kind of, but not really. And here's why. Urban renewal leverages all of the tax rates of the overlapping taxing jurisdictions. So if you were just to put away city money, you would be getting that 24% of the pie. But urban renewal puts away the city, the county, the ESD, the school district, all of that extra money. You're getting really 3-to-1 on your money, typically in an urban renewal area, as opposed to if it were just the city tax rates. And that's why urban renewal is such a powerful tool, and why you can't do it without an actual urban renewal area. This is a hypothetical property tax bill. It's just got random property taxing jurisdictions that would be representative of a typical city. And it shows a property in 2017 going into an urban renewal area or not going into an urban renewal area in 2018. From 2017 to 2018, the property value increases by that 3% from $100,000 to $103,000. And as you can see, without urban renewal, each of the taxing jurisdictions gets slightly more money. But with urban renewal, the amount that the taxing jurisdictions are getting on this property tax bill is the exact same, except there's an urban renewal line item at the end that says $44.28. And that's the process that's called the division of taxes. That is what urban renewal runs on, is taking money that would have, on growth in property taxes, that would have gone to other taxing entities, and putting it towards the urban renewal agency. Now, urban renewal tax collection actually gets very complicated very fast, because it used to be done one way and it made a lot of sense and everybody could understand it, but then measures 5 and 50 came around and Shiloh Inns sued the city of Portland, and now it's done a completely different way to make it all work with the assessors. And I like to break it down into 3 steps. The first thing you have to do in urban renewal is to calculate the amount of tax increment finance that is actually going to be collected. Then you distribute that over the city instead of just the urban renewal area, and then you can actually collect your property tax revenues. And this is another thing I had my design guy make a little infographic for, because it is so complicated. This is a hypothetical city, and each house in the city has $100,000 in assessed value. In the first year, we make an urban renewal area with $1 million of assessed value, representing 25% of the city. And the growth in that urban renewal area for this 1 year is that 3% total assessed value growth of $30,000. If the tax rate were $15 per thousand, the first year TIF collections would be $450 for this urban renewal area. So now we've calculated how much money the urban renewal area is authorized to collect. And this is the way that a lot of people think urban renewal should be collected, which is that $45 is distributed only to, or the $450 is distributed only to the houses inside the urban renewal area. But that's not the way that it's done anymore. That $450 is actually distributed amongst the whole city. And it's to comply with the regulations for $5 per thousand education and $10 per thousand general government. So, of course, in a real city, it's not equally distributed to each house, because, I'm using round numbers to make a point. But every house in the city of Cresswell, if this is adopted, every property will see an indication of urban renewal on their property tax bill. And so where does this money go? There's $1,500 from the frozen base that's going to these regular taxing jurisdictions. They also get $32.75 in new tax revenue. So it's not like the taxing jurisdictions aren't getting any new tax revenue anymore. They're still getting new tax revenue. And then there's $12.25 of new revenue going to the urban renewal agency from each house. So that's how the whole city doesn't get frozen in this whole thing. And the summary is, the division of taxes doesn't increase property taxes. It takes property tax increases that were already occurring before urban renewal, would occur if urban renewal weren't adopted, and directs that to a different fund. And there will be a line item for everyone in the city of Cresswell if this is adopted. So now, urban renewal sounds great, but there is always something that, it's not free money. It comes from somewhere. It comes from taxing districts, just like the county and the school districts. The overlapping taxing districts continue to receive the money from the frozen base, as I've said earlier, but they temporarily forego the money that would have been the growth. Now, especially in Cresswell, there's this concept called but for urban renewal, that the growth wouldn't have occurred but for the urban renewal investment. This industrial land in Cresswell, like Michael said at the beginning of the presentation, has been vacant for 20 years. And it's not developing. And it's probably not going to develop unless the city does something about it. So the increase in tax revenue from those properties, once they develop, that will go to the urban renewal area, wouldn't have happened without urban renewal investment. And so is it really revenue that's being foregone? Or is it really hypothetical revenue that's only generated if urban renewal happens? That's what urban renewal and but for urban renewal is all about. School districts. Everybody wants to know how urban renewal affects school districts, and it's very unique. No other taxing district is like this. This is a regular taxing district. It impacts their local property tax revenues, which is their direct revenue source. And so it's a direct impact. The school districts, they collect their local property tax revenues, but then they aren't authorized to spend their local property tax revenues until their local property tax revenues are combined with all of the other schools in the state and become the statewide property tax revenue pool for the state school fund. Now, the state school fund has several sources of income. It has the statewide property tax revenue pool, has the state general fund, it has lottery funds, and it has other local sources. What happens is once all of this money is combined, the state school fund comes up with their per pupil number from the equalization formula. And that takes into account whether a school is big or small, the transportation needs, the special students needs, teacher experience, all of these things. And then each school district gets a unique per pupil number. $500. You get $500 per student in your district. Urban renewal does not impact at the per pupil level. And that is the direct revenue source for a school district. Urban renewal is going to impact over on the left-hand side at the local property tax revenue level. And so what is really impacting directly is the state school fund. But the state school fund then establishes these per pupil numbers and distributes the money to the schools. And so we call it an indirect impact because that's the best you can do. And there's also the question of whether or not, if urban renewal were to go away, the state would just contribute less money from the general fund because of the influx in money from the property taxes. We don't know because they have their per pupil numbers they're supposed to hit, and if they can hit it with less money from the general fund, maybe they wouldn't contribute as much money from the general fund. So we don't know how to quantify urban renewal's impact to a local school district. There are some limitations on urban renewal. For a city the size of Cresswell, which is under 50,000, 25% of the assessed value or the acreage can be in an urban renewal area at any given time. There are some existing plan limitations. So once your plan is established, when you amend it, there are limitations. You cannot increase in size by more than 20% of the original acreage. And that's set in stone. You can never increase by more than 20% of the original acreage. You cannot increase your maximum indebtedness by more than 20% while indexed for inflation without some special approval called concurrence. which is approval of what represents 75% of the permanent rate levy of taxing districts. Usually the city, the county, and the school district approve of a maximum indebtedness increase, and it then has achieved concurrence. How is a plan adopted? We've gone through the agency review step with Cresswell, and now we're here on the county briefing and vote if there are unincorporated properties step. There are unincorporated properties, so the county will be voting on whether or not to approve this plan. Then we're going to go to the Cresswell Planning Commission, and the Cresswell Planning Commission will review this for its conformance to the comprehensive plan. And then we'll have a city council hearing and vote to actually adopt the plan for the city of Cresswell. This is the proposed boundary, and Michael, if you want to talk a little bit about the rationale behind the boundary, we're getting into the Cresswell portion of this presentation.
Sure, thanks. Just I'll start off with a correction. Said earlier about how it's looked the same for about 20 years in Cresswell. Bald Knob hasn't been vacant for 20 years. It's only been dormant for about 10 years, but its most recent investment was 1979. That provides any sort of indication. But the boundary was selected to include over on the west side, that more rectangular section is our downtown area. Right now, that is pretty much the majority residential, but it's zoned for downtown commercial use. And we hope that with some smarter street investments, we can encourage and coerce more economic development in the area. To the south, on the east side of Highway 99, we have upwards of 30 acres of usable industrial land that's currently in a brownfield state and is not served by adequate transportation or sewer or water infrastructure. Up the north side, we have a lot of commercial land north of Highway 222, Cloverdale, Oregon Avenue. There's also a lot of residential uses right now. A fair bit of that is currently low-income housing at the moment, zoned commercial, so it's unlikely that would develop in a quick manner. But we did make sure to include the right-of-way for Highway 99 as it goes north, so that we may make street improvements for pedestrian safety, as well as for freight traffic. And to the far north, that big chunk right there is our northern industrial land that's currently just grass. It's a pretty ideal greenfield development situation, just adjacent to I-5 and on 99. Our boundary does, if you notice, extend across Interstate 5, just barely, to touch our airport. You can't see it. Our airport is where the legend of this map is. Our airport right now isn't served by water or sewer. It's served by water, right?
Only for emergency purposes.
Right. So our airport we see as an economic development tool, and we'd like to be able to serve it. We're keeping the option open, but we don't have any projects planned right now to bore under I-5 and provide sewer and water infrastructure. It's just a potential we'd like to keep open.
And then those red parcels down there are the unincorporated properties. Those little parcels.
And why we are here.
Yeah, exactly. So this is, I talked about the statutory limitations for urban renewal. The acreage is 22.77%, and the assessed value is only 10.75%. If the urban renewal area was performing up to par with the rest of the city, you would expect these two numbers to be equal. But they're not, because this urban renewal area is underperforming. So now we're going to get into the proposed projects, and the categories are transportation infrastructure, sewer infrastructure, water infrastructure, and later we're going to have a map that has where these projects are going in the urban renewal area. Maximum indebtedness for this area is $12,500,000, and the amount in 2018 dollars or uninflated dollars is for projects is $6,471,663. So that's how much money, if you're looking at project estimates today, you can spend for this urban renewal area. These are the project allocations. There's a bit applied for administration, not too terribly much over a 30-year term. And then it's pretty much equal for the project categories. And then this is the map that I was talking about, and if Michael wants to.
Yeah, you guys can veto, and I can spare you the details on this if you would rather not hear about the specific projects, but
I'd like to hear about it.
great. I'd love to talk about them then. So the light blue projects are roadway projects. We have, one of them disappeared behind the darker blue and the yellow or green. I can't tell what color that is. Disappeared on the highway to the north, but we do plan on updating the entire roadway to our urban growth boundaries, north and south on Highway 99. It's a pretty heavy lift. We plan on cooperating pretty thoroughly with ODOT on that, both in terms of construction and funding and planning. That's listed, all these projects listed are in our either new transportation system plan, new water system master plan, or 2014 wastewater master plan. So these are all relatively recently designed and planned for. So we plan on serving the northern industrial property with wastewater and water. That will require a couple thousand feet of construction on Highway 99. That does leave and re-enter our city limits. Although it's my understanding it's not a great deal to the county for that doesn't really have much impact on the county. We have some pedestrian safety improvement projects planned for the downtown area as we plan on diverting traffic away from that jog intersection and into our downtown. It's our hope that we can provide multimodal access right there, and we have a transit hub at our city parking lot right there, where LTD stops through and folks can park their bikes and park their cars and take the bus to Eugene, since many of our residents are commuters.
How often does that bus stop there?
Once an hour between 9 a.m. and I think 6 p.m. On city council nights, I've seen it as late as 9 p.m., but I'm not sure if that's regular. And one exciting project is directly off the I-5 southbound off-ramp. We've planned for a new roadway that would plug directly into the north side of the Bald Knob Mill site. That project is of particular importance because you can't really get a semi-truck in and out of Bald Knob, and for an industrial site of its size, you would expect semi-access. We noted it's also served with rail, so it's a very interesting site for us to develop. The majority of the rest of the projects are upsizing, hardening, and replacing old infrastructure that serves our backbone to the city.
And then these are the specific projects. I don't know if we want to go through item by item. I think Michael did a pretty good job of covering. But you can see there are quite a few projects that are planned.
So we made a specific purpose not to include any quote-unquote fun projects. A lot of urban renewal areas have storefront improvement loan funds or things like that, facade improvement grants. Something we did experiment with was the idea of sidewalk improvement reimbursements in our downtown area. But we've decided to fund that through our city's economic development funds and keep the urban renewal plan as concrete as we can in terms of.
Concrete.
Not the pun.
So these are the project priorities of the plan, and they're in both the plan and the report. I don't know if you guys need me to read these to you or if you saw them in the plan and report. And this is the graphic of the impact to the county of this projected urban renewal area. So the light blue is the total revenue that the county will collect over the life of the urban renewal area. And know that that bottom line there in darker color is not the bottom of the graph. That is the portion of the county's revenue that this urban renewal area is going to cause the county to forego each year. So that little itty bitty line is the impact to the county.
Yeah, that's our taxes from the entire county.
Yes, exactly.
And not just from the boundary of the district, so to be clear.
So we're looking at it in terms of your total taxable value and then what the actual impact is of the Crestwell urban renewal to that total taxable value. And do you have the specific numbers?
It's 1.6 million and change. Over 30 years.
Over 30 years, right.
So next steps for this urban renewal area after this is the Planning Commission meeting on October 25th and the City Council hearing on November 5th. And then it is now up to you to ask questions and decide what you want to do.
So, yeah, we're all available to you to answer any questions that you might have.
Commissioner Williams.
Thank you, Mr. Chair. I have much to say. I'll try and be pithy, but may not be easy. First of all, congratulations on getting to this point. As mayor in Cottage Grove, I came into that office with an urban renewal established. I was chair of urban renewal for 12 years in Cottage Grove. I get it. The infrastructure needs that communities have today are much more difficult to achieve improvement because, for obvious reasons, some of those monies that used to be available for this just aren't anymore. So urban renewal is a real great opportunity to make those improvements that you need. Water, sewer, absolutely essential. You can't pave over roads until you take care of the infrastructure that's buried underneath them. Bald Knob, been driving by that place for over 50 years. I'm very familiar with the property. I do have a question about that parcel north on 99. Is that in an enterprise zone?
The entire district is an enterprise zone.
That's awesome. You know, and lastly, and there's much that I could say, but I'm a local control guy. You folks in Cresswell know what you need, and I think that other agencies, whether they're the county or the state, need to help local government achieve their goals. And you had mentioned, you know, that hadn't been a lot of improvements over the last 20 years, and you referenced Bald Knob. That's true over there. I got to tell you, as a lifetime guy living 8 miles to the south of Cresswell, over the years, and specifically in the last 20 years, the transformation in downtown Cresswell, Oregon Avenue, New City Hall, medical services, it's a beautiful community. And a lot of that has happened in the last 20 years. You went through a refinement plan downtown, got new streets, and you made sidewalk repairs. I mean, it's absolute joy for me to go through Cresswell because as an old guy that's been in that area for a long time, I know what it used to look like, and it's transformed for the better. I'm excited about this project. I think it's the right way to go. Certainly helped us in Cottage Grove accomplish some things that we just couldn't have done. So congratulations again on getting there, and wish you the best. Thank you, Mr. Chair.
Commissioner Farr.
Well, I'll be short. Good job, you guys, really. A good 101, 201 presentation that you could present that to any level audience and they would understand what you were talking about. Very well done. I served as a Eugene City Councilor for 10 years. We double as the Urban Renewal Agency. So we're steeped in riverfront and downtown, and not everybody loves it. I happen to love it. I think it's one of the greatest ways that a city can utilize to the maximum the funding available to it. And it really is fair. By and large, it's fair because everybody benefits from the improvements that are made inside of the district. So I'm in favor of it. Even if that county portion were bigger, I'd still be in favor of it because I believe that you guys in Cresswell are right on the verge of something right now. You know, because of your location, close to the city of Eugene, close to the city of Cottage Grove, right on the I-5 corridor, something soon is going to happen in Cresswell. You guys are, with this movement right now, you're getting ready for it. You're getting ready for what's going to happen. The only thing I'd suggest is maybe you save a little bit on the side for beautification and for storefront renovation, because that may come in handy when people start to see how beautiful Cresswell is and what the opportunity, the economic opportunity that they have in Cresswell. So bravo, good work, good job. I'm on it.
Commissioner Lyken.
Thank you, Mr. Chair. A question as far as tax increment financing. So in Springfield, you have to have a vote by the public. Can the city council enact this?
Yes.
Yes.
There are very few cities in the state of Oregon that have to have a vote of the public for urban renewal.
Not ours, because people got mad about 40 years ago on urban renewal, and so they changed the charter in the city, so you have to have a vote by the public, which the two urban renewal districts that have been put in place under one Springfield Economic Development Agency is downtown and Glenwood. Glenwood passed with 72%, downtown passed with 68%. So the public was on board. Part of the reason why is because there was such a strong vision, and that's the area. So looking at this, it's obvious you're developing a vision for it, which is outstanding. The other piece on Bald Knob, and Sarah can attest to this, we have very few pieces of land that are probably more than 30 acres in Lane County that have accessibility from I-5 that can be used for, as I like to call, the cash register. So actually creating opportunity, creating jobs, and Bald Knob is one of those. So I think that's an important piece on it. Is Emerald Forest Products still in operation in Cresswell, do you know?
Yes.
They still are. That was their first mill. I don't know if you knew that, but that was their first operating mill, was at Cresswell. So, and then the other piece, I was glad to hear your conversation about the airport, and because frankly, Cresswell Airport really is a nice facility. It's the official backup to the Eugene Airport, so that's what's I always find interesting, and it's kind of in that banana belt. So while Eugene can get fogged in, that banana belt comes into play pretty well there at Cresswell. And the other thing that you have, and this is why I go to Cresswell, because I get on the freeway and they turn left, and is Emerald Valley. Frankly, it's one of the top championship golf courses in the state of Oregon. And as you can tell, a lot of the top amateur events are played there on an annual basis. And do you get yourself engaged with the Pliska family at all?
We have not, no. We're kind of still getting our legs underneath us as far as economic development, and we're trying to put some tools into our toolbox. I think Mr. Pliska has a fantastic hotel in our town.
He does.
I think he has fantastic facilities, as you point out, and I think there's a lot of potential there. I think this is one tool we can use to show people like him who have the capacity to come in and do nice developments, that we're ready.
I would recommend, he's a personal friend, and I've known he and his family for a long time, and so I would really, when you get a chance, get that engagement. He's pretty easy to talk to, honestly, Jim is. And then the other piece I'm going to add is that if you do, you go on your iPhone, you put in King Estates, it takes you right into downtown Cresswell, right on out, and that's going to be a nice place when all those 218 countries fly in. They're going to want to go to King Estates. It's going to be going right through your downtown. So it's going to be fantastic. So I look forward to that. But really cool. This is really neat what you have going on. And I really appreciate the comments from Commissioner Williams, and who's been at this and has been around this a long time and has watched Cresswell really develop. So congratulations.
Thank you very much. Appreciate the presentation. I was just curious, in the period of time that this is in place, the 30 years, what has to change for it not to be blighted? In other words, this blighted, what if tomorrow it becomes totally beautiful? Does it end because it's not blighted, or how flexible? Maybe I should ask you that question. If I saw a bum on Rodeo Boulevard, Rodeo Drive in Beverly Hills, would that make it blighted? Or, in other words, how much blight do you have to have before it's blighted? And is that really a pretty wide definition that if there's some blight, then the area within the map continues to be eligible for the favorable tax treatment?
Your urban renewal area only has to be blighted at the inception of the urban renewal area, because let's think about the situation where Cresswell takes out a bond, and then all of a sudden, if they were to say, oh yeah, you're not blighted anymore, you can't have tax increment, they can't make their payments. So that doesn't happen that way. But you're absolutely right. It's a very wide definition, and only some of your urban renewal area has to be blighted. And that's really because if you only took in blighted properties, you wouldn't make any money with urban renewal and wouldn't be able to do projects. So you have to have some of those high value, high assessed value properties along with your blight.
I just didn't want to be put in a position where I was going to cast a vote where I am agreeing that all of Crestwell is blighted.
Not agreeing.
I just wanted to be clear that I remember Crestwell, the friendly town, and to me, it's friendly. I wish the pie place was really open, but I guess that's maybe ancient history. But I think that it's marginally blighted enough for me to vote for this.
The conditions of blight we use to define the need for urban renewal in this case were all related to disinvestment and lack of infrastructure, not appearance or presence of any sort.
So there's no blight, it's just, on paper, there's just not enough investment.
That's what we chose to say.
Okay, very good. I agree with that.
Oh, well, I'll just say, I think it's a great idea. Been involved with the Florence Urban Renewal District quite a bit as the commission's representative on their board and making decisions. I will say, be careful about what how ambitious, particularly your Highway 99 project is. I think the Florence folks are feeling a lot of pain with the current bidding environment, and they tried to do a major project on 101, 126 in cooperation with ODOT, and their bids came in way above what the engineers' estimates were, and they're having to rethink their entire project down there. So just a word of warning. keep an eye on that as you're planning out those projects. And, and it's not just about being in concrete, it's really about being in ductile iron and C900, but used to be an engineer, so I appreciated getting the projects. And Crestwell has changed over 20 years. I mean, I've done some projects down there when I was with Branch Engineering in the mid-90s. I've raced my bicycle out of there up and over Ham Road and done some time trialing down there back when the Tour de Willamette was running. I think that was in the 90s too. And Main Street is far different from the 90s, and City Hall, which I got to spend some time in when we had the quarterly mayor's meeting down there. Was that summer? Had some yummy Thai food.
Right, that's right.
Yeah. One of the best Thai restaurants in the counties in Crestwell. Little known fact.
I'll let her know you said that.
Yeah, that was great. That was great food. So, this is really kind of exciting. I look forward to it. I have one question, though. With the overlap with the enterprise zone, is that going to impact some of the projections relative to income, because you can get a 3 or 5 year waiver on property taxes on any new capital investment for somebody if they apply and get approved? Is that being calculated into some of these projections?
So our financial specialist, Nick Popenook from Tiberius Solution, has dealt with multiple urban renewal areas that have enterprise zones. And generally, we take the most aggressive stance and say, okay, we're gonna assume that they can qualify for a 5 year. And, it is factored in. We do think about the enterprise zone. It's not something that we forget in our financial projections.
Good. Just was curious about that. I was going to ask if there was an overlapping enterprise zone. Somebody beat me to that punch, but it was specifically about the financial projections relative to that 3 to 5 year waiver. And if you guys have already counted in the 5 year, perfect. It's kind of one of the reasons why these things start slow. If you do get somebody in, they may actually not be paying that increment for up to 5 years, and all that, which is why a lot of urban renewal districts do what Florence did, which was finance a bond basically to pay for a major improvement up front based on those long-term revenues. And that's what they were attempting to do with this road project. And then the cost, the bids came way above the cost estimates, and having to rethink that whole thing. So it is a great tool, though, because, really, I've looked at those areas with developers 20 years ago, and the same issue was, as you're trying to choose a site to do an industrial project or a commercial project, what's it cost to get me the infrastructure? And it's all about the forma on the piece of land, and they're doing their due diligence. They realize they've got to tear up a state highway to improve the water and sewer infrastructure just to get to their site before they even have to do any of the on-site improvements. Suddenly, unless the land is basically free and a whole bunch of other stuff goes well, you're just not going to be able to get it to pencil out against a shovel-ready site out in West Eugene or something that's in an existing industrial subdivision. Yeah, and that's what Cresswell's had to deal with. You guys have done a lot, though. You've upgraded your sewage treatment plant. You know, you've got, yeah, you're working on it. You worked on your water treatment plant. Sorry, I was confusing the two. But you guys have been doing some stuff on your base infrastructure to serve the entire municipality. Now it's about some of just the extending that capacity into these industrial areas to be at the front property line to get these shovel-ready parcels. Because Commissioner Lycan hit the nail on the head. We don't have much industrial land that's right on I-5 like that. And then we've got one of these parcels that also has rail access. I mean, that's one of the reasons why we went after the Goal 14 exception in Goshen. Mm-hmm. And I kind of look forward to this developing and us getting Goshen moving ahead and that getting enough, 24/7 demand for transportation that maybe the buses will run either more frequently and for longer periods and on weekends, because there'll be a reason for them to run. As you look at that terminal in downtown Cresswell, it's hard for LTD to justify extending the services unless there's users for it. So, that's part of that, what comes first, more bus service or more demand for the bus service? We need to,
Right on the head.
yeah, we need the demand for bus service. So there's so many things that play into that. So this is really a great concept. I know we have a little tiny red portion of it, but I think you're going to get a yes out of us as one part of your 51% you're looking for. So, Commissioner Williams.
Well, Mr. Chair, thank you for the recognition. Before I'm going to make a motion here, but before I do that, I was remiss in my compliments to the city of Cresswell. I want to look at Sarah Means and the work that you do, but also that was as good a presentation as I have ever seen on urban renewal. That was thorough, it was concise, and it was easy for a simple guy like me to understand. So thank you for that. And with that, I would move approval of Board Order 18-10-16-09 in the matter of approving the urban renewal plan for the city of Cresswell.
Second.
It's been moved by Commissioner Williams, seconded by Commissioner Lycan to approve the Cresswell urban renewal plan. Commissioner Farr.
Just as you walk out of the door, you'll step into our downtown urban renewal area, look around and see the benefits of it, and the fruit of the urban renewal district, our library, the LCC downtown campus, the transit station. And if you go over to the Riverfront Research Park, you'll see the ORI building and other buildings that are occurring down there. And you guys are on the right track. You're using it in your way for your own community to serve your needs. So well done. Thank you.
Any further discussion to the motion? Seeing and hearing none, I'll call for the vote. All those in favor, please say aye.
Aye.
Any opposed? The motion passes unanimously. Thank you very much, everybody.
Thank you, Commissioners.
Thank you.
Thank you.
And that gets us back to our morning item on human resources and our 3 board orders, which I believe we have some staff stepping up to help us with. But I believe we were emailed these also.
That's correct.
So I think we've got them in order, and maybe what we can do is have, if you guys have any presentation at all, or we'll just go straight to motions on that.
No, I can just go through them really quick and apologize. Alana had an appointment, so I'm sitting in for her.
Sorry.
And so Darcy and Diana Jones worked on what the commissioners asked for in the 3 separate board orders you have in front of you. So Order 18-10-16-10 is in the matter of adjusting the base annual salaries of the Lane County's assessor, sheriff, and justice of the peace. And then the next one is 18-10-16-11 in the matter of adjusting the base annual salaries of Lane County's district attorney.
And then the last one, 18-10-16-12, is in the matter of adjusting the salaries of the commissioners.
Thank you. So with that, I would entertain a motion on 18-10-16-10. Commissioner Lykin.
Thank you, Mr. Chair. So I can move approval of Order 1810-1610 in the matter of adjusting the base annual salaries of Lane County's assessor, sheriff, and justice of the peace consistent with the market comparators.
Second?
It's been moved and seconded to pass Order 18-10-16-10. Any discussion to the motion? Seeing and hearing none, I'll call for the vote. All those in favor, please say aye.
Aye.
Any opposed? The motion passes 5-0. Thank you, Alice. Now I'll take a motion on 18-10-16-11. Commissioner Lykin.
Thank you, Mr. Chair. So at this time, I will be recusing myself from this board order. So if you allow me time to excuse myself from the podium due to a conflict of interest. Thank you, Mr. Chair.
Thank you. So Commissioner Lykin has recused himself. I will take a motion on 18-10-16-11.
Move approval.
It's been moved by Commissioner Sorensen.
Second?
Seconded by Commissioner Williams to approve 18-10-16-11 in the matter of adjusting the district attorney's salary. Any discussion to the motion? Seeing and hearing none, all those in favor, please say aye.
Aye.
Any opposed? The motion passes 4-0 with Commissioner Lykin recused. That brings us to 18-10-16-12. Is there a motion? Commissioner Lykin.
Thank you, Mr. Chair. I move approval of Order 1810-16-12 in the matter of adjusting the base annual salaries of Lane County's Board of Commissioners consistent with the market comparators.
Second.
Been moved by Commissioner Lykin, seconded by Commissioner Sorensen to approve 18-10-16-12 in the matter of adjusting the commissioners' salaries. Any discussion to the motion? Commissioner Farr.
Just make note that the Register Guard has already reported that we did this already.
Oh.
We
don't need to vote then.
Lane County Commissioners give themselves a raise.
Yeah, not noting that it was 2% COLAs.
Why don't you all join me and give them a surprise?
Oh, gosh, it'd almost be worth it. So it's been moved and seconded moved by Commissioner Lykin, seconded by Commissioner Sorensen. Further discussion to the motion.
Mr. Chair.
Commissioner Lykin.
I just want to say thank you, Commissioner Farr, for pointing out that the Register Guard already reported, because without you saying that, I would not have known. Thank you.
I can tell it's getting late. Any further discussion to the motion? I do want to note for the public's that the raise, quote, that we are getting is actually a 2% COLA per year, which is less than what Social Security recipients are receiving this year. So just for the record.
The raises will boost their pay by about $3,400.
Total over the 2 years. So with that, if there's no further discussion, I'll call for the vote. All those in favor, please say aye.
Aye.
Any opposed?
No.
Motion passes 3-2 with Commissioners Williams and Farr in opposition. Thank you, everyone, for going through that exercise. I think it was important.
Good job, you guys. And
and thank you for
board did a good
being
job.
willing to split all that up. It was important. Okay, so that gets us down to Commissioners' business, which we skipped this morning. Any announcements from commissioners? No announcements. Then down to agenda team requests, work session requests. I have one of my own. Are there any from the rest of the commission? So,
Mr. Chair, I just want to make note, I think Commissioner Sorensen had brought up the issue with AOC, and I believe that is scheduled for December 4th. Is that correct, the board meeting?
yeah, I think whatever the first meeting in
Yeah.
December is, I don't know what the date is.
Yeah.
Commissioner Sorensen.
I was going to mention that after Mr. Kyler was here earlier today, talking about housing and what Springfield was doing, I brought up the ballot measure, I think it's 102, I was wondering if it passes, I mean, if it doesn't pass, we don't need to do this, but if it passes, we could ask Mr. Kyler to come in and talk about what that is, whether there's anything that we could do or.
It's an interesting measure that allows using public funding for projects that won't be 100% owned by the public. So,
Yeah, it's called, it's a very broad definition of affordable housing, too.
yeah.
So just put in a request for, if it passes, then it's a kind of a November, December timeline.
Yeah, so we'll maybe put that one as a future agenda item if it passes.
Yeah.
Mr. Mokoheisky. So my one concern, and it's not so much agenda team request, we have 2 applicants for the Lane Planning Commission and need to go through an interview process. In the past, the 2 rural commissioners have served as a subcommittee to interview those candidates and make a recommendation to the board as a whole to make the appointment. And I just want to get affirmation that we can to continue with that practice and have Commissioner Williams and myself serve as the interview committee, if that's okay with the entirety of the board. Yep. I just gave us some work, Gary. We get to do 2 more interviews.
Fun work.
But it's nice to have 2 candidates, because for a long time, we only had 1.
Yeah, that's true.
So that's good. So we'll take care of that. Any other agenda team requests or work session requests or items for the board? If there's any other business for the board, then we'll do review of assignments, and I'll read us into executive session. Review of assignments?
So I don't know if you want that planning commission interview, if that was just a clarification.
I think it was just a clarification of who was on the committee, and go ahead to move forward with that.
Was Commissioner Sorensen's request an assignment? Did we take that as an assignment?
Yeah, assignment if 102 passes.
102 passes to bring a report back on it.
If 102 fails, it dies.
Yeah. Okay, that's all I had, and I'm sorry I stepped out for the Crestwell Urban Renewal. I was watching it upstairs, but I didn't see if there was any follow-up or action from that. Okay, does that cover it?
Yeah, I believe so. I think and we gave an assignment earlier to come back in 90 days on the armory, I think, was part of the direction we gave then.
Yeah, so let's include that as an assignment, so we have that on the list that we will report back in 90 days on the status of the assessment for the armory facility.
Okay, if there's no other business for the board, I'll read us into executive session. I don't expect a need to come out of executive session because I don't believe there's any decisions required from today's topic. So we will probably adjourn straight out of executive session. The Board of Commissioners will meet in executive session to conduct deliberations with persons designated by the governing body to carry on labor negotiations. This executive session is held pursuant to ORS 192-6602D, which allows the Board of Commissioners to meet in executive session for the purposes listed. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience will be asked to leave the room. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. No decisions may be made in executive session, and again, we will probably adjourn from executive session, and at the strike of the gavel, we'll be recessed and we'll reconvene in executive session in 5 minutes up in the Board of Commissioners conference room.